Welcome to California Virtual Family Law Attorney with founder Linda Garrett.
Welcome to California Virtual Family Law Attorney with founder Linda C. Garrett. My name is John Clements. Today we're talking about something a lot of people deal with after the divorce papers are signed, figuring out who actually gets what. So if you're still untangling property, debt, or financial questions post-divorce, or if you just don't understand how it's supposed to work in California, hey, you're in the right place. We're going to break down the rules surrounding community property, share what you can do without a lawyer, and point out where people often get stuck. All right, so first of all, Linda, welcome back to the show. Before we get started, how are you doing today?
Thank you. I am great. Thank you. I'm ready to go.
All right.
Excuse the voice, a little bit of allergies going on, so I have the more smoky voice today.
It's okay. It's going around.
But I'm excited to be here. Yes.
Well, let's dig into it then. So first of all, what does California's community property law really mean, and how does that affect what each person walks away with after a divorce?
Oh, that's a loaded question that could truly be 5 hours, but I'm going to condense it down, which is what I think I'm good at, which essentially is this. California is probably one of 6, maybe 9 states in all of the United States where we have what's known as community property laws. Other states have what are called equity. I'm not crystal clear, but they just divide based on what's fair. In California, it's more black and white in terms of if it, and I'll explain what the it is in a minute, if it was acquired during the marriage, it is community property. Now, what I'm saying now is I call it the 80-20 rule. 80% means what I'm saying is the rule. There's exceptions. The other 20% are the exceptions, and sometimes the exceptions to the exceptions. So again, as I'm sure most attorneys will tell you on a podcast, this is not legal advice. This is just general principles out the gate, which we call default starting. Okay, so what that means is we have to first define what is community property. And like I said, I'll do my best, but it's essentially a window period between date of marriage, which most people agree. Yep, we got married on that day. Yep, the priest, all those things, and date of separation. And let's just assume there's no dispute, but 30% of the time there is. But in this case, there is no dispute as to what the date of separation is. So in between this period was all the stuff we deposited into the 401k, to the checking, the savings, the house, the this, the that, et cetera, et cetera. Now, where people get confused is, well, you don't mean my 401k or the house that you bought it during the marriage, but it's in my name. So you don't mean those. Go, yep, I mean those too. So in California, we divide based on if there is no prenup or post-nup. Again, these are the 20%ers, but in the 80%er rule, we're going to divide based on this period of time. And we try to treat the divorce or the date of separation like a corpse, the dead body on the desk. And essentially what was on the desk on the date of separation, what was the balance, the checking, the savings, the credit cards, all those things. And so the courts will require the parties to try to settle their own case before the judge gets involved, which is nice because the goal there is to create a win-win. And sometimes the win-win is, you know, and I hate apples and you hate oranges. Why don't I take the 10 apples and you take the 10 oranges? They're happy. But that's not always the case. And I should say rarely the case. Instead, the judge will say, well, you guys can't decide. So like, I'm going to decide for you. 10 apples for you, 10 over here, and then nobody's really happy. So the bottom line is that we are a community property state. The courts will divide things based on what was acquired during the marriage, from date of marriage to date of separation. And so I think that answered the question.
Yeah, I think it does.
I lost track. Okay.
I think it's interesting then. I think what you're telling me is, for example, if I were to buy a car while I'm married and it's in my name, the title's in my name, and then, God forbid, I get a divorce, which I'm not planning to do if my wife is listening. I love her very much. It wouldn't matter that it's just, it wouldn't matter that it's just in my name. That's still a community asset. Is that what I'm hearing?
If I'm applying the 80% rule, that is correct. Because there's a lot of reasons the house or the car might be in your name. For example, your spouse has a lot of debt. Her credit score, sorry, wife, it's crappy as all heck. So we buy a house together. We say, well, we can't because if we put you on the loan, i.e. also the title, then our interest rate's going to shoot even higher than what it is on the market today. So as we know, interest rates are also tied into credit scores. So a lot of couples during the marriage will have one party sign what we call a quit claim deed. So essentially, it's just the one person buying the house and the one person on the debt as well. But that's what their plan was during the marriage. It was like their handshake. Yep, let's do that. It all works out. It's good for us, the family. Yay. Except that when it comes time to divorce now, husband says, well, that's my house. You signed there, right there. And the wife's like, not so quick, husband, because my intent was not to give you the house at time of divorce. My intent was to reduce our interest rate as a happily married couple.
Right. Right. Okay. So that's a good
Yes.
point. Yeah. So I
Hmm.
do have a question too, because obviously because of we're talking about the 80% and you have to kind of make generalizations to just get across the point. But what happens if you've got a situation where the divorce is finalized and there's still confusion or disagreement about who owns what?
Well, there lies a bigger problem. The question is, why are they confused, right? And usually that question is surrounded by one answer. The person did not have representation. And that's where we have this black and white, the feast or famine. Like, well, I have an attorney because I can afford one. So our settlement was somewhat fair. I didn't have an attorney, so I didn't know what I was doing. In fact, I have a new client who's Spanish speaking. And yes, she had an interpreter, but this one interpreter was interpreting for husband and wife, and they didn't understand the process and like, yeah, okay, okay, okay. And so in that case, the results were not fair. And so what I which ties back to what I've mentioned in my prior podcast, there's a middle way. Having a full rep attorney, having no attorney, and having a legal coach. That's the gap filler for I believe many people need is this gap filler. And I truly wish more attorneys would do this. So if you're a family law attorney watching this, talk to me, give me a call. I'll explain why it's so important. And it's so advantageous to your business as well. But that's the marketing, putting that aside. That's why we have these confusions, and it's not fair because they didn't know what they were doing. So, for example, the wife, I'll give a good example. Actually, this is a true story. A few years ago, a woman called me and said, sometimes I get these calls where they're just telling me what to do, like I'm a puppet. And they say, Garrett, I'd like you to type up an agreement my husband and I just reached. I said, okay. Well, I didn't say I would, but so what's the agreement first? And she says, well, he keeps his 401k and I will keep my jewelry. Okay. So how much is in the 401k? And she says, oh, it's about 44,000. I said, and how much of that money was put in during the marriage? She goes, all of it, but it's in his name. So it's his. I said, I'm listening. And I go, what about the jewelry? She goes, oh, I go, he gave you this jewelry? She goes, oh, no, Miss Garrett. This was for my aunt. She gave it to me when she passed on. I go, so this jewelry, he lets you keep it and he won't take it from you if you let him keep his 401k. She goes, yep. So type up the agreement. Yes, I laughed on the phone too. And I said, well, let me just tell you a bit about the law. So first of all, half of those deposits during the marriage are half yours. And that jewelry that you got from your Aunt Gertrude was never his. It's separate property. She goes, can I call you back?
Yeah, yeah, I can imagine. Yeah, I need to have a conversation.
You have to have a conversation. And so that's the thing. Had she not called me, she would have agreed to this and she would have thought it was fair. And then later on, when she kind of read some blog or saw my podcast years later, she goes, oh my gosh, I just gave up half of his 401k. Miss Garrett, years later, of course, can we do anything about this? And if there's not a showing of fraud or anything like that, it's like, nah, you're kind of stuck with it.
Oh man,
Again,
yeah.
because they didn't have an attorney. And that's again why I advocate so much for the coaching is because it's a what most people in America need, and for sure in California. And so yeah, so I had this one lady had coaching and she didn't make a mistake. And if more people get the in between, at least even just an hour or two to make an informed decision, You make an informed decision, and guess what? We're not confused, and it's not vague.
Yeah, exactly. And I would encourage our listeners to go back and listen to the previous episodes. We really dig into this whole idea of legal coaching
Hmm.
that you provide. It's a unique service. It's really beneficial. So I would definitely recommend folks,
Yes.
go listen to that.
Thank you.
Yeah, you bet. What about the scenario? Because I think you mentioned like we treat a divorce like a corpse on the table, which is an interesting
Hmm.
example we could dig into a little more
Yes.
later. But so what happens to assets that are acquired or bought after the separation, but before the divorce is finalized? What bucket do those fit in?
Excellent question. Excellent question, John. That is a little trickier. It's not as black and white as people think because they'll read some article, some blog that says, well, oh, I got this car after data separation, so it's mine. Or I bought this property, this real estate with a 80 grand down payment, and it's mine. And it sounds okay, except again, we talk, I listen, and I'm asking those questions. I said, well, was any of the community funds to buy this car? Yeah, and what? Well, the what is that you've now, even though it's not a matter of you buying it after separation, you use the money from the us portion to buy that. So it's the us portion is going to supersede the me action. And so then the same thing with the house. Sometimes the person will buy a house when they're separated and not divorced, and then they'll take out this huge chunk of money from their 401k. That's, by the way, for this conversation, all community property to either pay down a super large chunk of this down payment, or dare I say, which has happened on occasion, then buy the house in cash. So husband says, oh, well, this is my house too, because I bought it after separation. I said, well, where did the money come from? And the question is, well, does it matter? It doesn't matter, Miss Garrett. Does it? Yeah, it does. So we have these, it's more gray on the after separation period than it is before marriage, because before marriage, it's a little simpler. I bought the house before I married her, with few exceptions. Again, my 80-20 rule, I got to keep saying that because there's exceptions to every rule I will say on this podcast, any past podcast or future. But the 80-20 rule says it with the 80% is that usually before is you're pretty safe, again, with our 20%, just being super cautious here. But after separation, that's a little wonky because on top of the money issue, we 30% of the time will have a dispute of, I just have this story I got to tell you, a dispute on data separation. And why I'm laughing is I had a case many years ago. This is a true story. I can't make this up. Where I'll call him, I was going to say John. I'll call
Yeah,
him
don't call him
John.
John. Oh, okay. Fine.
I'll call him Jim. So Jim reaches out to me and says, I want to get divorced from my wife. And I said, okay, that'll work. I'm here. I can help you. And I say, hey, Jim, so when did you guys separate? He goes, so I'm typing this up in my notes, and he says, 26 years ago. 26 years ago. It's possible. So I said, okay. I go, and why do you say that was the date 26 years ago? He says, well, very clearly, I had an apartment complex before I got married. There's no dispute about that. My wife and I had a huge fight on Christmas morning. I packed my stuff into my suitcase. I moved into the apartment complex, used one of the apartments, and I've never returned. I'm like, okay. Remember that 20% rule?
Right.
So I do the petition for dissolution of marriage, and I put in his date. I did my due diligence. I asked the why. I said, well, that seems pretty clear. Never returned, lived on his own, all these things. So then I get the response from the wife, and her response of the FL 120 was data separation 2 months ago. I'm like, wait a minute, 26 years over here, 2 months over here. So I think I'm the one who's in the right here. So I call up the attorney and I'll say, okay, why does your client think it's 2 months and not 26 years? I go, you do understand that he's lived on his own in his own house, apartment for 26 years. And the attorney says, yeah, I know that. I said, okay, so what's the problem? She goes, well, didn't he tell you that they do everything as a family still? They have sex twice a week. They do this, they do that. And I said, no, it's my turn. Like, let me call you back. And so I call up my client, Jim. I say, Jim, I just spoke to the opposing counsel and she says it's 2 months. He goes, oh, gosh, no. I said, well, let me ask you some questions. Did you have sex with your wife these last 26 years? And his response, which is tattooed to my brain, was, quote, well, Miss Garrett, I did have to service my wife.
Oh my Lord.
Close quote. So I say, Jim, you know those 5 houses and complexes you've bought since date of your separation? Guess what? The community property. And he's like, what? So that's why it's also tricky, because then we have this moving target that possibly your data separation is not theirs. And so, so that's what's a little trickier on the post separation date. And that's why I call it a corpse, because unless you're really creepy, and there's out there, there are people that are creepy, but assuming the rest of us are within the norm, the other 99%, we don't have sex with a corpse. The corpse is in the morgue, in the refrigerator. And that's where it should stay until it's buried in the ground, i.e., the divorce is finalized. But being people who they are, there's many people who do interesting things. So Jim was not a happy camper
Yeah. I think
when
Jim
he
wanted to have his cake and eat it too. Yeah, sure. So just a few minutes left.
yes.
We've been talking, and I didn't expect the conversation to go in that route, but I'm kind of interested that it
Sorry.
did. No, it's all good. We've been talking about assets a lot, but I do want to, in our remaining time, talk about debts. Well, how are debts handled? Is it the same? Is it different?
Debts are, again, 80/20 rule, back to that. Yes, they're handled the same way, because my working definition is anything and everything acquired during the marriage, again, date of marriage, date of separation, is community property. Again, there's the 20% rule. But if we use the 80% rule, that means if you charge on the credit cards and use it for the benefit of the community, it doesn't include, for example, in the 20% for your mistress, that your wife knew nothing about. It's not for the community.
Right.
So
Yeah.
if you charge 20 grand on a card for the mistress, not included. But if it was for, clothing, food for the kids, repairs on the house, those are debts, and they're acquired if acquired during the marriage, and there's no dispute about that, then those get divided just the way the 401k and the houses do. That's an easy question.
Yeah, there you go. It
If we
is. Yeah,
stick to the
good.
80% rule.
Yeah, and I'm glad you didn't bring my nefarious past into it this time. I appreciate that.
Oh, let's go there.
Again, yeah, we listen to the past episodes and learn about my nefarious past. So I do have one more question for you as we kind of wrap
Sure.
it up. What's your message for someone who feels stuck? Maybe they're already divorced, but they're still struggling to get what they owed, or they don't even maybe understand their rights. What's your message to them?
Go back to that coaching or that consultation where you can speak to an attorney, any attorney in California who's licensed to practice law in California. And I would recommend, if this person is stuck, to do their vetting, their due diligence, to find someone who's experienced in family law. It's almost like medicine, right? We have our foot doctors, our heart doctors, our ear doctors. In law, we have the same thing. We have corporate lawyers, we have criminal law, we have all these things, and we are allowed as lawyers to jump around if you want. If I'm tired of family law and I've had my moments, I can go to criminal law. But so you want to find someone who's got several years, maybe at least 10 years in family law, because then they can help you, what we call issue spot, any concerns. Was there any fraud involved? And where I can see some problems is when a person does not fill out this form called a schedule of assets and debts, or property declaration, which is part of the we call the disclosure period, preliminary disclosures, which are required by law. They are mandatory, and they're supposed to, by law, be complete and thorough. And that's where, as an attorney, and other good family law attorneys will look to these forms to see, aha, am I missing any? Did he list? Oh, I have the perfect example where husband says, I have one checking with Chase, one savings with Chase. And he says, that's all I have. But we find out, we got an investigator, and he did some research, asset research, and he had several checking and several savings and a stock account with Schwab. So what would happen there? So let's just say they settle the case. Wife comes to me, now ex-wife, and says, well, I don't know. It just seems like he's spending money and I don't know where he's getting it from. So we find out that, yep, he did not disclose all the assets on these forms that are signed under penalty of perjury. And so then if we have this aha moment, like, aha, we found it, the smoking gun, then we can go back to court to let the court know that the husband or the wife, omitted an asset, and we have statutes on just that scenario. So the first thing is to figure out, with a licensed, experienced family law attorney, was there any errors, intentional errors or fraud in the process? Because if wife did not know about these other assets, then she was defrauded, and fraud is not protected by law.
Yeah, absolutely. Well, we're going to go and wrap it up there. And again, just I think the message is there are things you can do. And for people who want to know what those are, reach out to Linda. So Linda, thanks so much for being on the show today.
Oh, you're very welcome. Thank you for having me on the show.
Yeah. And for our listeners, again, we hope that today's episode clarified what property division looks like after a California divorce and what your options are if things don't feel fair. So for more information, you can reach out to Linda at lindacgarrettlaw.com. And as always, be sure to leave a comment, leave a review. It helps others find the support they need too. And with that, have a great day.
And thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.